disputes between counsel. Like maybe on examinations for discovery, the examining counsel asked a question and the deponent's counsel thought that it was an inappropriate question. Well, both counsel have the same power, so eventually they'll have to go to the court and say, hey, is this an appropriate question? So we typically, what we do in the preparing for trial stage is we take care of all these matters that have to be addressed before we go to trial. And it requires asking the court to do something for you. Now, whenever we ask the court to do something for us, and the court makes a decision, what the court does is they make an order. That's their decision, is an order. And I'm sure you guys have heard of the term order, right? Yes. Okay. So in order to get an order from the court, we have to do, there's a procedural test that we have to go through. What the process is called motions. Now, did you guys take motions at all in litigation?
Yes, we do.
Okay, so what do you guys know about motions? What is the whole idea of a motion?
The whole idea is that a motion is to ask the court to make an order on the party's behalf.
Right. Okay. So it's not necessarily, that's right. So the court is, you're just asking the court. That's it. A motion is just the process where you ask the court, can you make a decision for us about this case? It's not the final outcome. It's not the trial. It's just these interim decisions. And it may be decisions where both counsel are of opposing view. And like I said, each counsel has equal power. So it's only the court that can settle a dispute. But it could also be administrative matters where nobody's disputing anything, okay? But you still need the court, you need the court to endorse this, to have an order of the court. So an example would be, remember I told you guys, you got proofreading is key in a law clerk's job. You guys know that, right? So remember I told you guys that a title of proceedings, once a statement of claim is issued, once you have that seal from the court, and once it's been, you got a court file number and stuff like that, you cannot change the title of proceedings. You cannot do that. The only way you can do that is if you get an order from the court. So you would have to bring a motion, ask the court to do it. So a good example where both sides agree, maybe you as the law clerk, when you were typing up that statement of claim, you did a typo and you typed the wrong person's name altogether. So, you want to correct that because you don't want to have like if somebody made a typo and they typed up your name on a statement of claim, you certainly don't want to have your name on a statement of claim when it has nothing to do with you, right? So we've got to correct that. So both sides would have to go to the court and or one side would go to the court and ask the court to do this. The other side would agree to the order. So do you understand that? That's just an administrative matter where nobody's in dispute. It's just something you need a court order. Does that make sense?
Yes, that makes sense.
Okay, now motions are very, very complicated. And there is a huge procedure. I'm just going to give you a bit of background. You probably already know about motions through litigation. So I'm just going to give you a background so you do understand what you're doing and why you're doing it. I'm going to also let you know that your final exam is going to focus heavily on motions. In fact, the whole final exam will be on motion. So it will probably be putting together some sort of motion record. So I've broken this down into a couple of steps, okay? Right now, what I'm going to do is I'm just going to pull up my notes and we'll go over the points of motion so you guys get an understanding of why you're doing what you're doing, okay? Because you guys will be heavily involved in doing motion records as well. Now, can you guys see this?
Yes.
Okay, cool. Okay, so what I've already said here, okay, so motions, what you're doing is you're just asking the court to intervene, okay? So it could be on administrative matters or it could be on disputes, okay, where counsel has disputes. So let me see. So most motions, okay, like I said, this is the stage where most motions are heard when we're getting ready for trial. However, you can have a motion at any stage. You can have a motion in the pleading stage. You could have a motion in the discovery stage. Typically, most motions take place really in preparing for trial. Okay, and a lot of them might have to do with answering undertakings. Okay, so now I want you guys to get used to the terminology and the setup. Now, can any party ask the court, can any party start a motion? Can any party ask the court for an order? Is it always the plaintiff that brings a motion?
No, like either one can.
Yeah, plaintiff can bring a motion, a defendant can bring a motion, a third party can bring a motion. Whoever is going to ask the court for the order, who's going to start this process of a motion, is called the moving party. Okay, so motion is in motion, so you're moving. You're the moving party. If all the other parties are called the responding party, okay, so some responding parties may be active, some may not be active, okay? So it'll be the responding party. Now, a motion is brought before either a judge or a case management master or a registrar, okay? So these are three different positions in the court. Are you guys familiar with all the different positions there? Have you guys addressed like the difference between a judge and a master? Do you guys even know what a master is? What's a master? Do you guys know what a master is?
It's a level above a registrar, below a judge. It's somebody appointed by the government who's a lawyer and can make certain decisions, especially in this case on certain motions.
Excellent. Okay, so excellent. Okay, I'm glad you said that. I don't know when that happens. Sorry. Definitely, a lawyer has, well, a master has to be a lawyer. Okay, and you're dead on. They are appointed by the government. Okay, so typically there's like a lot of politics going into it. So if a lawyer wants to be a master, they want to progress in their career to that or whatever. I don't know why this is going weird. Sorry. They'll be appointed a master. They have authority, but they don't have as much authority as a judge. A judge can hear everything. A judge can hear absolutely everything. Whereas a master can only hear certain things. Okay, so they can only make decisions on certain things, like, you know, they may be things that are in disagreement. They may be settling a dispute, but it's not. There's not a lot of really complex issues that they can make decisions on. And what's a registrar, guys?
Court position in charge of court documents.
Yeah. So that's a good way of putting it. Okay, so a registrar is like the person behind the counter at the court. Exactly. So they're more of an administrative figurehead. So they can make decisions. They can make decisions like that, you know, changing, can you make an order about, nobody's disputing it, about the typo that you did. Okay, so they can make those decisions that are not contested. I'm just trying to pull up something right now. Sorry, I forgot to pull this up. Give me 2 seconds. Okay, so, hold on. Okay. Sorry, guys, I just got to pull up something so that you guys can see. It has to do with your assignment. Okay, so what we have to do is, there we go, that's what I wanted. We've got to decide who's going to hear it. If a judge can hear everything, then why wouldn't we just always, you know, decide to bring a motion before a judge, right? Well, the idea is we've got 3 different levels to decide so that we don't heavy load judges. We've only got so many judges and we can't fill up all their time. So we have to decide which motion, okay, the motion that we're bringing, is it going to be heard by a judge or a case management master or a registrar? Okay, so how we figure out who is going to hear this is typically all motions are brought, you know, under a rule. So if you guys had a motion where, you know, it was about answering undertakings, what you'd have to do is you guys have gone to the rules, you just look in the index, you go like examinations for discovery or undertakings, and you go to the rule that it will say. And the rule will say if there's a dispute about undertakings, a motion may be brought to, and it'll tell you whether it's going to be before a registrar, before a judge, or before a master. So what the wording says in the rules, if it's before a judge or a master, the rules will say a motion may be brought to the court. Otherwise, if it's just before a judge, it'll say a motion will be brought before a judge. So you have to look at the rules in order to know who is going to hear this particular motion. So I'll just give you an example where you guys had the assignment for Chapman. Did you guys do the assignment?
Yes,
Yes.
Yeah.
Okay, so if you look here, we have the assignment where we're going to strike the defendant's jury notice. Remember, the City of Toronto sent a jury notice to us. Do we want a jury in Chapman? Like, what? Tell me about our client. What's our client like? Will the jury like our client? What do you guys think?
No, I don't think they would.
Why? What's wrong with our client?
Well, they're gonna bring up the fact that he was basically kicking a homeless guy. Whether that's true or not, the jury will hear it, and that puts him in a bad light.
Exactly, okay? So we don't really want a jury. But just because we don't want a jury, that doesn't mean we can't have a jury, okay? So you have to have a valid reason. And what the actual action is called is to strike or to remove a jury notice, okay? That's the terminology. That's why it's in quotation marks. So whenever you see quotation marks, guys, those are the legal terminology, and I don't want you to variate from that at all, okay? Or deviate. So what we've done here is Robert Redford's told us, okay, we've got certain rules that we actually can rely upon to get that, okay? Just because we don't want it, we have to have legal grounds. So what he did is he looked up the rules, and he went into the rules and he looked up, okay, striking out a jury notice, okay? So that was rule 47, it was jury notice. And if you see here, it says right here, a motion may be brought to the court to strike out a jury notice. So in that case, just like notes say, whenever the rules use the word court, okay, that means either a judge or master. Otherwise, it would say judge. So in this case, it says court, it doesn't say judge. So who can actually hear the motion? Who can make the decision to strike out a jury notice?
So a judge or a master?
Exactly. And the reality is it's going to go to a master first because, again, we don't want to tie up all the judges' times, you know. So whenever you see court, it will typically go to a master first, okay? But either a judge or a master can hear it. Otherwise, if it's just a judge only, it will say judge. So did you guys get that? You have to have a rule to rely upon in order to understand who is going to hear the motion. Are you guys okay on that?
Yeah, I just have a quick question about like potentially the test. If like when you're going to give us the information for the test, are we going to have to look up the actual rules for a specific? No? Okay.
No, read the question, because I may say that it can be heard by a judge or a master. It may be heard by a master. If I say it's heard by a master, then you know it's court, okay? If I said judge or master, again, you know it's court. If I said judge only, you know it's judge.
Okay.
So I'm not going to get you to look up the rule.
Okay, thank you.
Okay. But I do want you to know how to interpret all the words, okay? Okay, is that fair?
Absolutely. Thank you, Meredith.
No problem. Okay. Okay, so that's how we figure out who makes the order. Who do we bring this motion before? Okay, so we've got court, which means judge or master. We've got judge, which means judge only. And if it's over the counter, it will say registrar. The registrar can make an order. Okay, where do we bring the motions? Well, we bring the motions in the same court that actually issued the statement of claim that has a court file on us. So if that's in Toronto, that's Toronto. If it's Milton or Scarborough or whatever, wherever, okay? So what you do is you look, you know where your proceedings were commenced, because every back sheet it says where the proceedings were commenced, or you can look on the notice of action or statement of claim to see where the action was issued, okay? Now, like I said, not all motions are when the lawyers dispute something. Okay, you can have motions that are on consent. Okay, you're asking the court, the moving party's asking the court for an order, and the responding parties all agree, so they consent to the order. So in that case, it's really quite easy, where all you have to do is you've got to give the motion material to the court, and you give a piece of paper that's called a consent, and it's signed by all the lawyers, and they say, yeah, we agree to this, we consent to this order. So that's stuff that the judge or master will look at. Okay, so you don't even have to show up. You don't have to argue anything. You don't have to file anything. Only the moving party gives material, and they also provide the court with the written document that has the signatures of all the lawyers that agree. Okay. You can also have motions that are opposed. Okay, so opposed is when each lawyer takes a different position. No, I don't agree with the moving party's order, so I'm going to file my material. And I'm going to have the judge look at my material. So it's either going to be written material, or you may even show up in court to argue it. Okay, so if you argue stuff, it could be virtually. So we could do it like via Zoom and stuff like that, or you can actually show up at the hearing, okay, at the court for a live hearing. Now we've got a third position that's called unopposed. And unopposed means that the responding party doesn't consent to the order, but they're also not going to argue the order. Okay, so they're not going to oppose it. So unopposed means I don't agree and I don't disagree with the order. Let the moving party go and do whatever they want to do. I couldn't care less. I'm not going to participate in this. Now, why would we have unopposed? Why would a lawyer say, okay, I don't care either way. Like, you go and do it. I couldn't care less.
It could be maybe just something like administrative, like a change in a spelling of something, or like something very banal, you know what I mean?
They just don't want to waste their client's money getting them involved in this at all.
Right.
So they don't care. It's not going to affect them one way or another. Okay, so go and get your order, do what you want. I'm not agreeing to it. I'm not disagreeing. I'm not participating. My client is not spending any money on this. Okay. So that's why we have unopposed. Now, with unopposed, the moving party still has to file written material with the court and give the court stuff to look at and decide on. You typically don't have to show up in court. You may or may not if the judge wants or the master wants clarification. Okay, but it's typically all done through writing, okay? Whereas opposed is done typically through writing and also virtual, or actually in-person motions, okay? So again, this kind of covers this stuff. Okay, so what does the court look at in order to, what do they consider when they're making their decision? So like I said, with opposed, what you're going to have is you're going to have your submissions. Submissions are typically just arguments. That's a word for arguments. So your argument can either be, well, it can be both. It can be written material. You can have written arguments, as well as oral arguments, where you have the virtual motions or the courtroom motions. Okay, if it's unopposed or it's on consent, the moving party is still going to file material. Okay, they don't really have to show up for virtual attendance or for an in-court room, okay? If it's on consent, you're obviously going to give that document that has the signature of all the parties consenting to the agreement. You're also going to give the court an order that's already written up for them. All the judge or master has to do is sign it. That's it. Okay, so it can really be done very quickly, okay, and unopposed or on consent. Okay, whether it's unopposed, opposed, or on consent, you need, at the very least, the moving party needs to prepare a notice of motion. However, for almost all motions, whether opposed, unopposed, or on consent, we have what's called a motion record, which actually is a book that contains a notice of motion. Okay, so the notice of motion is a document, okay? Motion record is a book that contains a bunch of documents, including a notice of motion. Are you guys okay on that?
Yes.
Okay. So the rules actually okay, so yeah, sorry, when you have motions, before I get into what a motion record looks like, we've got different types of motions, okay? So we've got short motions where these are opposed motions, and the court is saying, okay, it's a short motion because all counsel can argue everything in less than 2 hours. Okay. Any motions that the court is hearing is called over 2 hours is called a long motion. And there's different procedures for all of them, okay? So all we're gonna do in this class is deal with short motions, okay? So what you have to do is first book a date. Now, with motions, each court, like Toronto Court has one day that it listens to motions, okay? Milton Court has a different day that it listens to motions. So each court, depending on where you brought your action, where your action was commenced, you got to see what day of the week that court listens to motions. And when you book a motion, you're booking for that day. So if it's only Tuesdays, then you're booking for Tuesdays. And all motions start at either 9:30 or 10 o'clock. You can't book a specific time. What you have to do is just book for that day, and all the motions are put on a list, and the master judge just runs through the list, and here's the motions. So your lawyer or the articling student who's going to argue the motion has to be prepared at the beginning, at 10 o'clock or 9:30, whatever time they start, and wait. They got to wait until it comes to their case. Okay, so you just book a motion for the day, but you have to be ready at the beginning of that day. You got to show up at the beginning of that day. Okay, and they'll just run through the list. So when you book a motion, it's really easy, okay? You just got, it's a form that you just have to submit, okay? So it's just like this, it's in Inform, you've got, or actually in any of the software programs, okay? And all you gotta do is you just email it, you fill it in. For the most part, your lawyer will just fill it in or tell you what to fill in on it. You just have to say whether you're the moving party or whether you're a plaintiff or defendant, whether it's case managed or simplified. What's simplified procedure, guys? Case management is when the action is actually placed in a particular field called case management. Otherwise, it's just under ordinary procedure. And your lawyer will give you all this information, telling you how long everything's going to take. So they'll fill all of that in. And all you have to do is you just email this over you got the email address there, and they'll book a date for you. They'll inform you of the date. You can 3 choices of date, okay? But typically what's going to happen is you'll end up getting the first date more than likely, okay? So that will go over there, okay? And like I said, your lawyer for the most part will tell you this information or fill it in for you, okay? So that's just booking the motion first, okay? So then what you have to do is you've got to prepare your motion record, okay? As the moving party, you're going to have to prepare your motion record. And the rules require that you have to have certain material in certain format for a motion record, okay? So it's a book. So you're going to have a front page, which has the title of proceedings. That's a Word document that you create on your own. Okay, it's not a document that you get off of software. You don't get it off of Inform. You don't get it off of, ACL or anything like that. It's just a Word document that you create on your own. Just like any other book, you got a table of contents, okay? And a table of contents, index, whatever you want to call it. You guys have read many books. You know what a table of contents is. What is it? There. Each page has to be numbered in the upper right side. Okay, it can't be the upper left, can't be center. It's got to be the upper right side. This is the rules. Okay, this isn't me. This isn't Meredith. This isn't Humbert. This is the rules of civil procedure. Okay, so don't number the cover page or the back sheet. Okay, because you're going to have documents in there. Okay, your very first document that's going to be listed in your table of contents has to be the notice of motion. Okay, so this is a document on its own, but it's contained within a bigger document, okay, which is our book. So any document that's contained within the book, you don't need a back sheet. You just need a back sheet for your big document. So you're going to need a back sheet for your motion record. but I don't have to include my back sheet for any document that's inside that. So I don't need my back sheet for my notice of motion, okay? What you also need in there is you need an affidavit. What is an affidavit, guys? Just by definition, what is an affidavit?
A sworn statement?
A sworn statement. Exactly. So what we need here, we call it a supporting affidavit. So it's just going to be a sworn statement by somebody from the moving party who is just making statements saying, oh, I think we should get this order because of this and this and this. That's all it is. Okay, so it's a sworn statement supporting the order that you want. Okay, so that's why we call it a supporting affidavit. Then, you know, if you want to include any other material like transcripts or whatever, that comes after the affidavit. So you can do that. Okay. And your last thing is a back sheet. So if you're filing a hard copy, the back sheet's on this blue type of construction type of paper. Okay. Otherwise, if it's filed, which most of them are, if it's filed by the portal, then you don't need, I mean, obviously there's no colors to the virtual documents. So I'm just going to pull up the example. Okay, so to show you what we have. So we've got, this is the front page. This is the cover page, and it has the title of proceedings. It's a Word document. It's not something that was off of Inform. There's nothing that says the format has to be like this, that you have to have borders there, but it's a front page. So you're going to need the title of what the document is. So it's a motion record. Whose motion record? Okay. So you state whose motion record it is and whether you're the moving party or the responding party. And just like any other document, you got the date, and then you got the lawyer of record who's actually filing this document or serving this document. And then you got who it's going to, the lawyer of record of who it's going to. This could all be on one page, okay? There's nothing saying that you have to split that up into 2 pages. I just happen to. So you could have that all on one page if you can fit it. Okay, so that's just a Word document you guys create. Just like the index. Okay, so the index, here we go. You can call it table of contents if you want. There's nothing that says it has to be set up like this. You may want to have your page numbers over here, or you may want to have ... and then you do 4 to 6. However you want to set it up, that's how you can do it, okay? But it's a table of contents that tells me, okay, at page 7, I will find an affidavit. Well, let me go down to page 7. Okay, so here's page 7. I better find an affidavit because my index says so. There we go. I got the affidavit, okay? So that's all it is. That's something you create through Word, okay? Your cover page and your index. That's your work product, however you want it to look, okay? Then you get into your notice of motion. That is a court document that we can get off of Inform, okay? So we've got the notice of motion, and I'll go through it in a second about the contents of it. But if you see, we've got the notice of motion. I don't have a back sheet to it because it's included in a bigger document, okay? I get right into the affidavit. I don't have a back sheet to the affidavit because it's included in a bigger document. But I do have the back sheet to the motion record, okay? Because this is the document that I'm creating. So you got the back sheet to that. Are you guys okay with the contents? The contents of a motion record, are you okay?
I thought I read somewhere that that form, the request to schedule the motion, was also to be included in the motion record.
To be included? No, you can file it with the motion record if you want to do that, or you can file it ahead of time to secure your date for sure. It's not included with. It may accompany the motion record. It's not part of the motion record.
Right. Yeah, I was just a bit confused with that. Okay.
Okay. Typically, you're going to do it ahead of time anyway, but you can do it at the same time. You can upload it at the same time. Anything else?